will go on the record in the matter 25 TR 231, 232, and 233, State of Wisconsin versus Ashley Funk. The state appears through Assistant District Attorney Jose Ballard in person. We have Bruce Anderson, Defense Counsel, in person with Ms. Funk. We're set today for a status conference. A jury demand has been made in this case. Mr. Anderson, can you please update the court?
Your Honor, this case has not resolved yet. Frankly, I have not gone over my issues with Mr. Schmidt at this point. Now I guess I'll have a new prosecutor to do that with. I think another status case, another status conference, perhaps 45 days out or thereabouts before we set it for trial.
September 11th, does that work?
I'm sorry, I have a trial all day in Polk that day. You have me here on the 22nd of September for a couple of things.
I do. Let me, oh, right in the morning, is that
Yeah.
when I scheduled you?
Mhm.
All right. Why don't we, the two estates. So why don't I do 9:30 on September 22nd?
Excellent.
9:30, September 22nd. We'll see you there. Now, at the other cases, you indicated that you may appear by Zoom. Are you going to request that with this? Because if you are, then I'm going to say Ms. Funk can appear by Zoom as well.
I think I will request Zoom on this also.
You know how to use Zoom?
Yep.
All
Or you
right.
come to my
So
office.
I will allow you to appear by Zoom too. I see you're in luck. That's not too far, but if your attorney is going to be by Zoom, it's easier if you're by Zoom.
Okay.
Okay?
Real
But
good.
if you want to be in person, that's your call.
Okay.
All right? You can come get your notice and you're free to leave.
Ashley, I need you to give me your phone number.
Are you still at 2175 224th Avenue?
Yes.
And can you provide your telephone number to the clerk, please? Thank you. Miss Almendinger.
No, if we could do Mr. Raleigh, I think
Oh.
would be,
Okay, that's fine too.
he'll be,
Oh, I honestly didn't see that you were on Mr. Raleigh's case. Mr. Raleigh, come on up. We will go on the record in the matter 22 TR 939, 23 TR 51, State of Wisconsin versus Michael Raleigh. The state appears through Assistant District Attorney Jose Villard in person. We have Mr. Raleigh appearing in person with his counsel, Bruce Anderson. We're set today in this matter for a motion for entry of judgment. The court has seen the request from the state indicating that Mr. Raleigh has not provided his AODA assessment and proof of that within 60 days. Mr. Anderson, can you please update the court?
I can. Court will note that the Rule 25 Minnesota AODA has now been completed and filed with the court. My client just didn't remember that he had to get it done within 60 days, according to my conversations with him. He apologizes to the court. It's clear that he has now completed that. He has maintained his sobriety. And I think he would also like to speak to the court that, he wasn't up to speed on what he should have gotten done. In essence, we're asking the court to accept the fact that it took him a long time, frankly, to get it done. But it is now completed, and fortunately, nothing bad has happened in the interim.
Mr. Raleigh, is there anything you want to add or you want to say to the court?
Oh, I apologize. I didn't realize it was one of them things just got put on the back burner, and I had a lot of things going on last year, and it just kept getting pushed back. And even when I got my license renewed in March, there was a there was $200 fine from the state of Wisconsin that I paid that and it was done. I was just under the assumption that was good, or I don't really have an excuse. I'm sorry. I just didn't do it.
Okay, Mr. Villard, do you oppose the request to accept, I guess, the late filing?
Your Honor, at this time, given the fact that we did receive the AODA assessment, the state is withdrawing its motion to revoke the DJOC.
All right, so then the motion is revoked. It is still ongoing. I don't recall the end date for the deferred judgment of
I
conviction.
think it's 2029.
It was 5 years, Your Honor, but
Yes.
it was unclear whether that was from when I was arrested or
When
when
you
I
sign the
was,
document,
that's
So
kind of what I figured.
February 26, 2029.
And I got a ways to go
You
yet.
have a ways to go, and you've been remaining sober.
Yes, ma'am.
Very glad to hear that. So now everything's covered with the AODA, and it's just follow all of the other requirements and follow the law, and you're good to go. All right?
Yes, ma'am.
All right, thank you. And I do have a commitment order though for you. That is a warrant. You owe $1,407.40.
do.
That's what I'm being informed. You can come see the clerk. She may be able to show you exactly what that is. Well, you can't. It's already entered and you owe it.
What is that for, Judge?
That's separate, that's nothing to do with this.
Yeah, I'm gonna pull it up right now.
I know it is, I think it reads off my.
And that would be,
Oh,
yeah,
that's a zoning matter or DNR matter. I
that
suppose.
is, it is. And judgment was entered back in February. I mean, what you, I'm not giving you, Mr. Anderson can give you something. Okay. Okay, sounds good.
Cash, check, credit card.
Either or.
We can help you out the front counter out there.
Okay.
Thank you. Then we are adjourned.
Not bad.
Now, Miss Almendinger.
That's DNR thing. I was raking leads on my shoreline. You can't do it.
Okay.
All right, Miss Almendinger. So there's going to be testimony. Excuse me for 1 second. All right. We will go on the record in the matters 24 CF 176, 24 TR 741, and 742. State of Wisconsin versus Rebecca Almendinger. The state appears through District Attorney Kevin Schmidt in person. Ms. Almendinger appears in person with her counsel, Bruce Anderson. We're set today in this matter for a motion hearing. And that is proceeding as such. Is that correct, Mr. Anderson?
It is.
All right. Mr. Schmidt, are you going to proceed first, or are you going to ask Mr. Anderson? I do not see an officer, so I'm not seeing that we need officer testimony.
No, officers aren't relevant to this, and since it's Attorney Anderson's motion and his burden, I think he'd call the first witness.
All right,
Well,
Mr. Anderson.
I think I disagree with that. It's my motion, I agree. But once the court grants a motion based on my motion, or grants a hearing rather, based upon my motion and the affidavit, I think the burden shifts.
I think Attorney Anderson's referring to State v. Banger, which was overturned in 2022 in State v. Clark, where the Supreme Court of Wisconsin held that the burden shift only occurs if there's a transcript. If there's no transcript, Bentley applies, meaning the burden is on the defendant to prove by clear and convincing evidence that a manifest injustice occurred.
That is true.
All right.
So, Mr. Anderson, please call your first witness. I'm going to presume Ms. Almendinger.
Yes.
Ms. Almendinger, you may come forward, raise your right hand. You're going to be sworn in, and then come have a seat over here at the witness stand.
Do you swear that the testimony you are about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name
Rebecca Joel Almendinger,
and what is your current address?
2353 260th Avenue, Cushing, Wisconsin, 54006,
What is your date of birth?
September 23rd, 1982.
And you were convicted of an operating while intoxicated in Washington County, Minnesota in 2005. Is that correct?
Yes,
And how old were you when that occurred?
23 years old,
Okay.
or 22. I was
right.
almost 23.
What is your educational background?
I'm a high school graduate.
Any post-high school?
No.
At any time have you studied law?
No,
Have you ever studied the United States Constitution
no,
or anything about the American legal system?
nope,
Have you studied legal vocabulary?
no.
Now, in this 2005 case in the state of Minnesota, were you represented by a lawyer?
No, I was not.
And when you were found guilty, or any time prior to that, did the judge personally address you about your rights to having a lawyer?
No,
Did you basically get told by a prosecutor what was going to happen?
yeah, for the most part, other than talking to some friends that also weren't legal, didn't have a legal background, that said, just get it over with.
Was that your first offense?
Yeah.
Had you ever been involved in any legal proceedings up to that point in your life?
No,
Okay. If you can, if you recall, do you remember how long that court appearance took?
minutes. It was just, I walked in, I pled guilty, and that was it.
Okay.
You know,
I believe you might have filled out a form. Do you recall filling out a form?
yeah, I think there was a form that just stated that I understood that I was pleading guilty to the charges.
Of operating while intoxicated?
Yes,
At any time during from the night you got arrested for that case, until you made your final and perhaps only court appearance. Is that your only court appearance?
I believe so, yes.
Were you ever represented by a lawyer?
No, I
Did you
never,
ever even consult with a lawyer?
no, I didn't.
Okay.
I just have to stop you right now. Never mind, you can continue. Sorry, I thought I missed something, but I got it now.
Did the judge in that case ask you questions about what you knew about the law?
No,
Did the judge specifically ask you if you wanted a lawyer?
no,
Did the judge ask you or tell you rather? Did the judge tell you that if you needed a lawyer for that case, the court could appoint one or would appoint one for you?
no,
Did you know about the fact that you could have demanded a jury trial?
no, I did not know that.
Did you know that you could, that you were presumed innocent? Or did you think you were, based on what you'd seen in the case, did you say, well, I guess I have to plead guilty?
That's how I felt. I mean, I knew that
Yeah.
I was charged with the DWI because of my blood alcohol level at the time, and I just didn't ever even think it was something you could argue against.
Did the court advise you of what the maximum penalties could have been for that offense?
I don't recall if that was talked about. The prosecutor talked to me ahead of time about what, if I pled guilty, what the penalties, they would charge, but I don't know that I knew what the maximums would be.
So the prosecutor was the one who was giving you advice, basically.
Yeah, for the most part.
Okay. Did you actually know what the prosecution, which in this case was the Forest Lake City Attorney, correct?
Yep.
Did you know what they were going to have to prove to find you guilty?
No.
This prosecutor told you what was going to happen?
Yep.
No further questions.
Mr. Schmidt, questions?
Hi, did you successfully graduate high school? At that
Yes.
time you entered your plea?
Yep.
Did you get held back at all?
No.
You got the diploma?
Yes,
Okay. How'd you do in school?
I did well. I didn't have any, I was A/B student.
AB student. Did you do civics classes in high school back then?
What would civics classes talk about? I did a correspondence homeschooling program throughout 9th or 10th, 11th, and 12th grade.
Oh, were
And
you
it-
homeschooled through high school?
Yeah,
Okay. Did you learn about government operation? Like democracy,
yeah, the general,
you know, like,
what democracy is and stuff.
like the separation of powers in the courts and things like that?
I'm sure that was in there.
Okay. Did you ever watch TV or movies when you were that old?
I'm sure I did.
Okay. So when you were 23, you had never heard that people have a right to an attorney in criminal cases.
It's not that I had never heard that. It was just I had the understanding that the way I was raised, you don't argue against, if you're in trouble for something, you just suck it up. You deal with it. It wasn't a consideration in my mind that I would argue with the police or argue with the court system.
Okay, let me back it up then. That OWI, you probably were arrested, came into contact with an officer at some point, and that led to the complaint in Minnesota, right?
Yep.
What actually happened? What were the facts of your interaction with the police and why they thought you committed an OWI?
Relevance?
And this is from 20 years ago, where she's literally said she doesn't remember some things in her direct testimony. I'm seeing what she remembers about the incident.
Overruled.
I left a bar and grill. I pulled out of the parking lot onto Highway 61, and I was following a friend, and my friend they went through a light. They didn't go through a red light, but they went through the green light, and then the light turned red and I slammed on my brakes because I didn't want to go through the red light. And there was a package of light bulbs on my passenger seat that went flying and broke. And when I went to try to stop that, I swerved a little bit. And the cop was behind me and he saw the swerve, and that's what he pulled me over for.
I noticed you didn't mention anything about alcohol at all. Was
I
there any
left a bar
alcohol?
and yeah, there was alcohol involved. I had been drinking at the bar.
Okay. Was there a blood or breath test?
Yes, there was a
And
breath test.
were you made aware of what the results were prior to you entering a plea?
objection as to what type of test, whether it was a PBT or a chemical test.
Sustained.
I guess I can get around. I'm asking, do you think you were intoxicated back then?
Yes,
Okay. So part of the reason you entered a guilty plea is you think you were guilty.
yes,
Okay. So according to the motion your attorney filed, he's essentially saying that something was wrong with your plea colloquy back then. And if that were the case and that were true, you'd be able to withdraw your plea entirely. Why haven't you gone back to Minnesota and withdrawn your plea?
I guess to be perfectly honest, until you just said that right now, I didn't know that I could go back 20 years and do that.
Okay. She just didn't think of it.
It's not that I didn't think of it. I had no idea that that was an option to go back and argue something that I already pled to 20 years ago.
Okay. So I'm going to fast forward then to our questions we're asking about the plea colloquy. If you recall, I went on this detour asking about the actual OWI when you referenced the way I was brought up, you own up to what you did, right? So going back to that question then.
Objection to the characterization of her testimony. She said she was raised not to argue with the government.
She also did say that she was intoxicated and thought she was guilty.
Anyways,
Sustained.
sustained.
Sorry, overruled him.
Okay. So I kind of got cut off there. So let me shortcut the question then. Would it be accurate to say then that you did know about the ability to get an attorney, but you just didn't want to because you thought you were guilty and because of your upbringing?
Yes, I would say that's accurate, but also I wasn't aware of what the benefits of having an attorney would have been.
I mean, if you did have an attorney, would you have, given your upbringing, fought the case even though you thought you were guilty?
Well, years later now, from what I understand, had I had an attorney, maybe there would have been different, how do you put? There would have been steps I could have taken to, I guess, lessen the consequences of it. Maybe steps I could have taken to get more help back then, things like that.
Like what help?
Addressing why I was driving and drinking. You know, the types of programs I'm in now, that kind of stuff.
Okay. So you knew you had a right to an attorney. You didn't seek one back then because you felt you were guilty, but also you're saying now with what you know, 20 years later, I think I have a better idea of what attorneys can provide better than I did back then.
Yeah.
Okay. Do you remember what you thought about what attorneys did back then?
I mean, I knew attorneys. I mean, I knew that an attorney would, like, I don't know, quote unquote, fight for you, or, you know, obviously the attorneys understand the laws and how the court system works. You know, all that all works together.
Okay. So back then, did you know that there was a presumption of innocence? Is that term is sometimes used?
Well, I'm sure I had heard plenty of times innocent until proven guilty. But in my mind, back then, the until proven guilty was, you know, the breathalyzer that night.
Because the breathalyzer result was one of the things that made you think you were guilty.
Yep.
Okay. And Did you know that you had the right to testify or call witnesses if you did have a trial? Like you could put on your own.
I
defense.
guess I can't answer that honestly. Back then, I don't know if I would have ever realized that a DWI goes to a jury trial. Like, honestly, I thought it was just something that was between the prosecutor, the defendant, and the judge. I didn't even realize that that was again, like I said, I naive about the system.
Did you get jail back then?
No,
Were you told it was possible to get jail?
yes,
Were you told it was possible to get jail if you didn't accept a plea bargain?
yes,
And that was part of your consideration as to why you entered the plea bargain?
yes.
Okay. Gonna show you a document.
Yeah, okay. Yeah.
I'm gonna show you this document, let you handle it, and I'm gonna ask you about it. Do you recognize that document?
I mean, I can read it and know what it is. I'm not going to say that, yeah, I remember seeing this, but
What is
I'm
it?
sure it says it's a affidavit in support of motion to exclude evidence of prior convictions from sentencing.
Is that the motion Attorney Anderson originally submitted on March 13th? The unsigned one?
It's not the motion.
I'm sorry, the affidavit.
Thank you.
Yeah,
And he had shown that to you before he filed it?
is this the one, Bruce, is this the one that,
You can't ask him questions.
oh,
Just
But,
yeah.
answer
Your Honor,
to
I'm
that.
going to object to the unsigned one because I believe the filed document was filed on March 18th, included corrections and additional and different statements, things that were crossed out and so on.
It was definitely amended. Where are you going with this?
This is a filed document. This is document 26 in the case.
I do have that document pulled up. I'm going to overrule to the extent that I'm going to provide instruction that just answer what you know. You don't know, you don't know.
okay.
Judge, could she be provided with a copy of the other file?
I will be providing that later. This is my questioning, not Attorney Anderson's.
She will,
Well,
I will make sure that she has copies of both. And I believe the question was simply, did you review this prior to it being filed?
Yes, this unsigned one before the edits.
I don't know.
I don't know what the relevance of unsigned document is.
You filed it.
I did that.
I'm going to take it for what it is. She answered, she's unsure.
Okay, so you're not sure if you've reviewed that document. I'm going to hand you another document now. I want you to hang on to that one up there. You recognize that one?
Yes,
What is that?
this is the one I signed.
Why does the signed one have all those pencil edits and the unsigned one does not?
I don't know.
Did you know that Attorney Anderson had filed that unsigned one?
I knew that he wanted to get one filed.
Okay. I'm going to show you. Let me ask you this. The hearing where you had the plea colloquy with the judge way back in the early 2000s on the OWI, who was the judge?
Objection assumes a fact, not an evidence.
I don't know.
What is the fact, not evidence?
You can, if there's an objection, Ms. Allmendinger, just wait until I give a response as to whether or not you have to answer. I understand you're nervous right now, but you objected facts not into evidence, and your question was what facts are not into evidence?
She's not testified that there was an actual plea colloquy. In fact, I believe she said there wasn't what's known as a colloquy. I didn't use that exact word, But the question said at the time she had the plea colloquy.
I'm gonna sustain and just on the basis, I'm gonna guess foundation.
You had said when you were in direct examination with your attorney, you were in front of the judge at some point for the plea and sentencing for the OWI, correct?
I believe so.
You don't remember?
And for the record, I'm just going to say this was from Minnesota, so it is a DWI in Minnesota, but in Wisconsin, they are OWIs. And so Mr. Schmidt is kind of interchanging them simply because Wisconsin uses OWI, not DWI. So you can just infer them as the same.
Okay.
Okay.
Do you remember seeing a judge at all?
I believe that I think I did see a judge after talking to the prosecuting attorney.
But do you have any memory of the interaction with the judge?
I have a memory of standing at a podium and the judge asking what I pled or I guess I'm assuming it was the judge asking what I pled and I pled guilty and then prosecutor agreed to it.
You say you assume it was the judge. Why are you only assuming it's a judge?
Well, because I was in a courtroom and there was the person sitting kind of like this and
For the record, Ms. Almendinger has pointed to the court's bench.
Were they in robes?
I would imagine you're asking me a bunch of details about that long ago. I mean, yes, I would say it was a judge.
Okay. Do you remember anything the judge said?
Like I just said, he asked what I pled and I pled guilty. And then he asked the prosecutor if that was acceptable. I believe the prosecutor said something about accepting it, that we had worked out a plea.
Is the only thing he asked you how you pled?
Yes,
He didn't ask any other questions the whole time.
yes.
Did he say what your sentence was?
I believe the prosecutor is the one that told me that.
The judge didn't pronounce any sentence. The prosecutor said what it was.
You can take your time and think about it.
The prosecutor did tell the judge what we had agreed on, and then the judge repeated it back.
Okay. But you don't remember who the judge was?
No,
Do you remember who the prosecutor was?
no.
Okay. So jumping ahead now, at some point you attempted to get documents to help you at this hearing at the Minnesota courthouse, like more recently, correct?
Mhm.
How did that go?
Rebecca, you have to say yes or no.
Yes.
Thank you, Mr. Mayor.
It didn't go well.
Could you elaborate?
They didn't provide, they said they didn't have any records. They said they themselves had nothing on file of it. And then they directed me to their website to look on there and I didn't find anything on there.
Okay. Do you have any intellectual disability or delayed learning abilities?
No.
Because you're an AV student, correct?
Yep. Yes.
Did you do some sort of questionnaire for the court when you were at the sentencing for the DWI back in the early 2000s?
Objection to the form of the question.
I don't.
Just Wait 1 second. Can you repeat the question?
Did you do some sort of plea questionnaire at the sentencing for your DWI in the early 2000s?
And what was your objection?
At the sentencing would imply that it may have been done with the judge
And
as
or the
opposed to before.
I mean, there's nothing wrong with the question. If she has a response like that, she can make it. I think he's trying to testify for her.
Then the question's vague.
I'm going to overrule that. If you recall what happened at the sentencing, you may answer.
I don't know.
You don't know if you ever did a plea questionnaire.
I don't know if I did a plea questionnaire at the sentencing.
Okay, did you ever do one?
I don't know.
You don't know if you ever did. I'm gonna show you a document.
I need to look at it later.
That's okay. I'll send you a copy of it.
Yeah.
So I want to ask you specifically about pages 3 and 4 on that. Do you recognize those at all?
I recognize my writing. I can't say I actually recognize not that, I guess I don't remember the document from back then, but I do recognize my writing.
You recognize you're writing it, but you don't remember the document.
Right.
Okay. Okay. When you were 23, would you have signed something like this without reading it?
Objection calls for speculation.
It's not speculation, it's about yourself.
I will overrule it.
Yeah, I probably would have. I was nervous in the situation and probably just wanted to get it over with and move on with my life.
Okay. All right, I have no further questions on that.
Just a moment, Judge. I'm trying to get something up here.
Yeah, and then I'll just take the exhibits back.
I'm sorry, I didn't hear what Mr. Schmidt said.
He's taking the exhibits back.
Could I see the exhibits, please?
This one.
I don't need to see these. You can have these back.
You have any further questions?
No, non-direct
All right.
or cross.
Okay. Mr. Anderson, do you have additional redirect?
As soon as I review these,
That's fine. Take your turn.
best I can. Ms. Almendinger, do you remember if you filled out these forms, did you fill them out in the presence of the judge or the prosecutor? If you remember.
I don't honestly remember.
Okay. And I note that, you can correct me, second page of one of these documents, which is entitled petition to plead guilty. Second page, it doesn't have any signature where the judge accepted that. You agree?
Yes.
No further questions.
Recross.
No. I do have documents that I'm obviously going to submit to the court now. I'm submitting a number of documents in a specific order. First is the document 26. That's the unsigned affidavit. The next is the document that both Attorney Anderson and I have been referring to with her, the plea colloquy from Minnesota. After that is the signed version of the affidavit, document 28. And the next two documents are transcripts, the transcript of the March 18th status conference and transcript of the March 24th status conference.
Are you offering them as exhibits and are you having them individually marked?
Yes, I'm showing them to Attorney Anderson before I walk over to the clerk for that.
No objection to those documents being marked.
And move into evidence.
Court will receive the documents and the exhibits. Anything further?
No.
All right, you may step down. Thank you. No other witnesses
Or the witnesses.
and no witnesses?
No.
Okay. All right, well, the clerk is marking the documents. Mr. Anderson, argument.
If I could have the documents, I'd like to refer to them in my argument.
That's fine, we can wait.
I'm not going to rehash all of the testimony the court has already heard and it's fresh in the court's mind. The unsigned affidavit, I acknowledge was filed as an unsigned document along with the motion that I filed that triggered the need for this hearing today. The whole point of that affidavit was what I interpreted from Ms. Almendinger and put it into an affidavit format. And then before she signed it under oath, before me as a notary, she had additional information and certainly things that she struck from that affidavit. So I think the unsigned affidavit really carries little or no weight. The signed affidavit is what I think is the most important thing here. And I would ask the court to accept that affidavit as opposed to the unsigned. And that affidavit is Exhibit 3. The unsigned is Exhibit 1. What I think is important in the documents that have been submitted. I'm going to have to ask. Oh, what's been submitted, but apparently is a 4-page document, which is Exhibit 2. they're not numbered, but I think, as I've already indicated, the document which is entitled petition to plead guilty in DWI, gross misdemeanor or misdemeanor case. What's significant is the fact that petition and plea accepted by, and it's got all series of blanks for dates and so on, as well as judge of district court. That portion is blank. Ms. Almendinger has testified that the court proceeding just took a matter of minutes. That document that I referenced, which is the last 2 pages of Exhibit 2, is tantamount to our plea questionnaire and waiver of rights. And that is a document that in Wisconsin, the court clearly goes over with someone seeking to make a plea. The Minnesota one even takes it a step further. If something is done, and again, there's no evidence that anything was done with this, the judge then signs off on the plea petition, which then in essence is the acceptance of it. And that's absolutely blank. And of course, it's also blank as to her right to a lawyer. Now, the sentencing order, which is the first 2 pages, I don't know who may have filled this out. It does appear to have a facsimile, or rather a certification stamp. But I don't know what it says. It doesn't appear that it has marked either certified, sure, correct, or record in my office. If it does, that's obscured by other printing. So I don't know what that document may be. But even then, I think it's important to note that it appears to be signed by a judge of district court, but it doesn't indicate who may have filled out that form up to that point. And there's been no testimony as to any related preparation by the judge. It clearly does indicate no defense attorney. I think it's also important to note that this offense occurred on just a moment, I want to make sure I get the right date here. 4/6 of 2006, and this plea hearing happened apparently the 25th, less than 20 days later. So it appears to be a hurried, shall I say, entry into the court and a plea at that time. Clearly, she didn't have a lawyer. I don't know why a judge might not have signed off on a form that clearly is set up for a judge's signature when he did in fact sign off on this other document that was prepared by some unknown person. So, Judge, I realize our appellate courts have gone to great lengths to make it more difficult on these older cases because evidence is not available in many cases. In this case, I think it's interesting how there is evidence available, which in fact, the judge in Minnesota left blank. It would seem to me, just as a matter of practice, if a judge had gone over that entire form with Ms. Almendinger, the judge would have taken the extra step to date and sign and failed to do so. Then when a sentencing order is presented to him, that's whether it was filled out by him or not, I don't know. But as I look at his signature and the date that he placed on it, those appear to be significantly different penmanship. But But that, I mean, I'm no penmanship expert, but nonetheless, the sentencing order, again, at that time done in handwriting, is different than the plea colloquy. And clearly the judge failed to sign off on the plea colloquy, accepting Ms. Allmendinger's filled out document. So with that said, I would ask the court to rule that the conviction from 2006 in the state of Minnesota not.
I have those.
Pardon me?
I have those. You
Oh,
just
I was
got.
gonna give them to the court because I got them from the court.
I know.
All right.
Thank you.
In any event, the judge, I would ask that the court rule that the 2006 conviction is tainted, not in accordance with what the law must be in Wisconsin. And that's the standard that should be met, not just what might have happened in Minnesota. Ms. Allmendinger, yes, she had a high school diploma. That certainly doesn't qualify her to know much about the law. Prosecutors always bring up, well, did you watch movies and TV shows? I can't think of ever having seen a lawyer type show or a law enforcement type show where an operating while intoxicated charge is handled through an hour long or even a half hour long show from Perry Mason and Dragnet all the way up through the current time. Yeah, people had lawyers, but those lawyers are for serious things that were being shown in those TV shows, not shown in traffic matters. Becky testified that you didn't question authority, basically. They stopped her, picked her up. She'd been drinking. She, without checking on any defenses that might have been available, any errors that might have been made by a law enforcement officer in the testing process, any videos that might have been available to question the reasonable suspicion for the stop or the probable cause for the arrest. So I don't know what, she doesn't know what might have even been available at that time. Whether that department even had such technology, but it's certainly in that 20-day period when she made her initial appearance in court and she decided, boom, I'll take, she takes the fall without talking with a lawyer. And then we have the unsigned plea colloquy. It just seems a person in Becky's shoes, and I think she used the statement, well, the breathalyzer showed something, but it wasn't checked. The process was not followed. You know, this is why these older convictions, because they were just treated like a slap on the wrist. They weren't the serious consequences of the movies and TV shows where people were given the right to counsel. This was a minor matter that is now a very serious matter that obviously there's no real transcript of the actual hearing, whatever it may have been, if even it was done on the record. So I'd ask the court not to consider the 2006 conviction.
All right, thank you, Mr. Schmidt.
I think unequivocally, Mr. Anderson has not met his burden. As the court probably recalls, historically speaking, collateral attack motions were probably the most common motion we got in any criminal case pre-2022. The reason why was if there wasn't a transcript and the burden's on the state to prove anything, and you have the defendant saying just, I don't remember, or later on when that got shut down by the courts, I do remember, and I wasn't colloquied, it would be impossible for the state to prevail on that because of where the burden was. The courts have shifted that since then. So here's the rub of the problem. Miss Allmendinger, she comes here today, has tremendous incentive to lie simply because of the criminal charges against her. The difference between an OWI 4 and an OWI 3 is the difference between a felony and a misdemeanor. A person has great self-interest against penal harm in these hearings saying, I do remember it didn't happen that way. Additionally, I think the court seen from the testimony of Ms. Allmendinger,
Wait, I need to have maintenance stop.
it's pretty distracting.
All right, hopefully they can get the message.
And yeah, the whole point of why Clark existed is there's supposed to be a presumption of regularity in judgments of conviction. There's a great public interest in finality of the judgment, and doing the burden shifting didn't make sense in that sort of scenario. So did Mr. Anderson meet clear and convincing evidence just off of testimony of his client? And I'd say no. There's a reason I submitted these documents and in this order. So I'm going to relate a bit of the procedural history here. Attorney Anderson came to court and submitted the motion and the unsigned affidavit. Part of the reason why I had the transcript of the status conference March 18th is he directly said to the court he was filing that unsigned affidavit and was just filing a signed one later. So it was intended to secure this hearing, that unsigned one. That was submitted by Attorney Anderson on behalf of Ms. Allmendinger to meet his burden for the production to get this hearing. So to say it should just be disregarded, shouldn't exist, is nonsense. When we look at that second document, the one that she did sign, I want the court to pay attention to what was added there. We just heard great testimony from here today about she doesn't know the law even though she's an A student from high school. What was added in between the first affidavit and the second? At sub 7, I was not provided nor did I sign a guilty plea question or waiver of rights form. And then they just wrote in that complied with WI procedures. Why would Rebecca Allmendinger say that? How does she know what complies with Wisconsin procedures? They've merely just crossed off all the rights that at the time of my waiver of right to counsel and guilt to be mentioned above, I was advised of constitutional rights. They struck all those off, just crossed them off, and then crossed off the right appointed to court by public defender and just wrote as no plea colloquy was done by the judge. What happened in between these affidavits is the state providing that plea questionnaire that she recognized having her name and her signature and her handwriting on it. You'll notice it was handwritten. It even gives her narrative of what happened. I drove a car after drinking alcohol and tested 0.08 or more. It has her signature on it. It has a circle around the sub for waiver of attorney, which does list all of the rights associated with what you have for a criminal case. And this is an incident that happened 20 years ago. She can remember all the specifics that would help her for this hearing, but can't remember any of the specifics that would hurt her. Didn't remember this plea questionnaire, claimed she went to the courts. They said it didn't exist. And then here's a certified copy of it from the courts. That's the purpose of the second transcript of Attorney Anderson telling the courts, hey, Rebecca Allmendinger went to Minnesota, asked for the records, told me that they said they had no responsive records. I submitted that because I didn't know if she'd be testifying to that today, and she did. Put that all together, does that mean clear and convincing evidence of a manifest injustice? It does not. It's the self-serving testimony of a defendant. If you accepted Attorney Anderson's argument that what happened today is sufficient to get rid of a past conviction, then what the court's holding is clear and convincing evidence of a manifest injustice is met. Any case, there's not a transcript or a defendant's just willing to say those things. Because the reality is he complains about nothing contradicted and people not showing up to testify. It's his burden. He could have looked for the judge. He could have looked for the clerk. Him shrugging his arms and saying, well, all we have is my client. What a shame. That's his problem because it's his burden. He tries to shove it off onto the state, just as Clark Court said, you can't do that anymore. We're here for Bentley. The burden's on the defendant. And just having a defendant say, I remember some things and not others, isn't enough. Not only that, but her testimony she gave, she did know these rights and she understood them. The reason she entered her guilty plea in court was because she was guilty and she wanted to accept responsibility. I think that one thing we've noticed from sort of comments today in Attorney Anderson's argument and comments at a previous court, Attorney Anderson believes that the classic plea colloquy is something unique in Wisconsin and that other places don't do it, or we shouldn't assume other places do it. And if the plea colloquy didn't happen, then the violation occurs. This, of course, contradicts Wisconsin case law. State v. Serrano, 2017, WI 42, at paragraph 21, that's spelled SURIANO, specifically recognized that the classic colloquy was never intended to provide any protection greater than what the US Constitution provides. It's the bare minimum. It's what every state does. And furthermore, just showing that a plea, let's say the court believes the defendant that a judge came in, asked how you plead, did no colloquy, which is an extreme claim with no extreme evidence backing up just the self-serving defendant. If the court actually believed that, that still wouldn't be sufficient to meet the burden. State v. Ernst, 2005, WI 107, paragraph 25. Just alleging that a plea colloquy is defective or missing is not enough to meet the collateral attack standard. You also have to show your client didn't understand the rights themselves. Just showing the plea colloquy didn't exist, not enough. And I don't think you've shown that, because Rebecca Allmendinger comes off as a pretty intelligent person. She was an A student in high school. She said she knew the rights, but quite frankly was raised too good by her parents, raised to accept responsibility for her actions. I think based on that, the court cannot find that the defendant has met their burden. Thank you.
Do you have any rebuttal? You don't need to.
The record is what the record is, Judge.
All right, thank you. I am taking this under advisement because obviously I've not been able to review the exhibits except for the ones that have been already filed in the case. So I'll get a written decision out promptly. Anything further other than that? Well, we do need to set another date. Mr. Anderson, would you like your September 22nd date?
Sure. Let's call it Bruce Anderson Day. Let's fill it up.
How about we fill it in? We just double book it with the 9:30.
Okay.
So 9:30, September 22nd. We will see you then.
What time did you say?
9:30.
And that's just the oral ruling, right?
I'm gonna do a written decision, but it'll be a status after that decision.
Okay, because I won't be there for that day.
Well, you'll get the written a lot sooner than that day.
Okay.
Zoom info?
She'll have a notice.
What? Zoom? Zoom? Yeah, Zoom is fine. You may appear by Zoom as well. Your attorney will most likely be appearing by Zoom on that date. So I'm okay if you appear by Zoom. It's actually easier for the court.
Okay.
But you may come in person. That's your right. Okay. All right. Thank you. You can come get your notice and you're free to leave. Are you going to be able to, Amy, are you going to be able to get the exhibits in? Well, I don't need them like today, but
Yeah, I can get them scanned in today.
okay. Thank you. All right, Mr. O'Sullivan, can you hear me? I need to change clerks out. Can you hear me, Mr. O'Sullivan?
Yes, Ron.
Okay, thank you. As soon as we get the clerk swapped, we're ready to go. But Mr. Benson did withdraw, but I do not have a defendant. I don't think. They're here. Yes. So I do have Miss Matthew Webster and your Jane McGuire. All right. You may come up here and have a seat. I apologize. I've never seen you before.
super fun in here. Great time also.
And it was been loud. Maintenance is doing something upstairs.
Told them, I'm like, when those people come to file, if I'm not out here, you make them stay. 'Cause I'm not fixing it after the fact.
We will go on the record in the matter 24 CV 151, Sarah Bark et al. Versus Matthew Webster et al. Appearances are, we do have appearing in person, Matthew Webster and Jane McGuire. Ryan Benson was counsel of record for defendants. He did request to withdraw, and he did properly inform you. You discussed that, correct, Mr. Webster?
Yeah, we were informed by mail late Friday afternoon.
Friday, yeah, it was signed on the 16th, so perhaps you got it late in the mail. And we have Rory O'Sullivan, who is counsel for plaintiff, appearing by video conferencing. Mr. Webster and or Ms. McGuire, are you seeking additional or subsequent counsel?
Correct.
Yes.
Okay, and have you already spoken with somebody or?
Spoke with somebody yesterday, but of the timing of receiving this on a Friday and not knowing until, we had the court date today, we're waiting to hear back. But as I understand, this is for setting a hearing at a later date.
Yes,
Okay.
and so you're not sure if that attorney is going to be retained?
I spoke to somebody yesterday and they're doing their research to make sure there's no conflict of interest. They said they would get back with me.
Just out of curiosity, because I do have a lot of attorneys coming in here and I can look at their calendar and see if they will be in this county on that date and time. Who is the attorney? A possibility.
Let me pull his name back up if that's okay. I'm
That's
sorry.
totally fine.
I didn't turn my phone off. I'm sorry about that.
Because if it's a possibility, then hopefully I can schedule something on the same time when I know that that individual will be here.
Steve, sorry. It's forwarded to me. Anders Hellquist is who I contacted.
Okay.
We have him on August 28th. It looks for a different CV. So let's see what.
On August 28th.
Oh,
Okay.
wait, that looks like it's just a review with Mary. Sorry.
Okay.
If there's anything else. Oh, they're all reviews. I don't have anything specifically.
All right. So we don't have anything specifically. They're just simply reviews in which that attorney and or firm will be here touching base, not for a hearing. So then most likely it'll be by telephone. But we can set a date. And if you do retain an attorney and it doesn't work for that attorney, then they would need to call my assistant and she can arrange a different date and time and make sure that works with Mr. O'Sullivan's calendar as well as the courts. Okay.
Sounds great. Thank you.
All right. So we're here for a scheduling conference, but notice of motion and motion. So we are, no, that's, what would we be scheduling, Mr. O'Sullivan?
I think Attorney Benson and I had thought we would put in place a full scheduling order, but in light of the fact that the defendants are hiring sort of subsequent counsel, I think it makes sense just to set another status or scheduling conference like this, and hopefully attorneys what's his name, Hellquist?
Anders and Hellquist.
Will be on the case by then, and we can put a scheduling order in place.
All right. So what I'm going to do again is schedule it for a date and time. And for the record, because of this next hearing, I don't know what you want to do, but any attorney that you retain can appear by video or by telephone for this hearing, because it's just going to be to set dates to keep the matter moving so we know what's going to happen when. Okay. So again, telephone and or Zoom appearance for you, for the attorney, totally fine. Mr. O'Sullivan, can you do 11:45? Well, just wait. Sorry, I have to double look at what I have skipped. No, I cannot do that. Are Are we looking at sooner rather than later? Would July 31st be too soon?
How's your schedule? The sooner,
I could do 9 o'clock. Either 9 o'clock, anytime between 9 and 10:30, Mr. O'Sullivan, by Zoom on July 31st.
Yeah,
Well,
that's all
actually,
fine.
no, I'm double looking. So 9 o'clock. So let's schedule 9 o'clock on July 31st. Again, if it doesn't work for a retained attorney, have them immediately contact my judicial assistant. And then she'll be in contact with Mr. O'Sullivan to get a different date and time. The next hearing is simply going to be scheduling dates.
correct.
Okay?
And would you be able to provide us with the phone number of whoever we should contact?
Yes, it's going to
Okay.
be on this notice.
Okay,
And so you'll come up here and you'll get the notice from the clerk and then you'll be free to go.
okay.
Okay? All right, thank you. Anything further, Mr. O'Sullivan?
No, yeah.
Okay, then we are adjourned. Thank you.